In McDonald Douglas, Justice Powell, said this may be done in setting out the prima facie case. This may be done by showing, one, that he belongs to a racial minority. What work does that do?
We think that that first prong identifies the protected class to which the plaintiff belongs and therefore focuses the litigation on whether the discrimination occurred on the basis of that protected class. We don't think it does the work that the Court of Appeals and the other courts that have adopted the background circumstance thinks it does, namely that McDonnell Douglas was predicated on some assumption about the rate at which different groups were discriminated against. The court has told us that the McDonnell Douglas presumption arises because of a different insight about employers, that they act for reasons and will be able to provide reasons, so that if this is the rare employer who can't come forward with any non-discriminatory reason for their action, the reason becomes more likely discriminatory. And that is an insight that holds good regardless of the identity of the plaintiff. Of course, that's not to say that a plaintiff who makes out a prima facie case is necessarily going to trial. In virtually every case, an employer will come forward with some non-discriminatory reason for their actions, and then the question will focus on whether that reason is pretextual or whether there's otherwise evidence to indicate that the employer acted for a discriminatory reason. And that itself is a difficult burden for plaintiffs to meet. We reject the Sixth Circuit's test because it's adding an additional atextual burden at step one that risks screening out cases that might otherwise satisfy the statute standard for liability.
Ms. Robertson, could you give us a little background about the EEOC's interpretation of the statute? Because it has a different approach, right?
No, the EEOC has a different approach than what the Sixth Circuit took.
Than what the Sixth Circuit. Yeah, sorry, I didn't mean than you do. I meant than the Sixth Circuit.
Yes, the EEOC has rejected the background circumstances rule. It applies the same prima facie case, the one this court articulated in McDonnell Douglas, for all plaintiffs. And it's been consistent with that because it understands this court's subsequent decisions in McDonnell and Burdine and Fernco to reject the idea that McDonnell Douglas turned on the race or identity of the plaintiff.
And, I asked before whether this would lead to a floodgate problem, as the department says, then you're going to have all these people filing suits. But the EEOC, am I remembering right, it was like 2001, and it's consistently had this interpretation of the statute. What has the EEOC's experience been?
The EEOC has had this interpretation since 2006. The EEOC, to be clear, while it does investigate all charges, parties don't need the EEOC to conclude that there is reasonable cause to proceed. EEOC will always issue a right to sue letter. But I will say that in our experience as an employer who regularly litigates these cases as a defendant, we don't need a higher prima facie case to weed out cases without merit. That's because in every case, the government can provide a non-discriminatory reason for its action. And so the case will proceed to step three, whether or not that reason is a pretext or whether or not we ultimately acted for a discriminatory reason. And that in itself, as I said, is a high hurdle. And so if a plaintiff can't satisfy that bar, they won't go to trial. So we share Ohio's concerns with making sure that meritless cases don't reach trial. We simply think that raising the standard at step one would be exactly the wrong way to address that concern because it would focus parties on a question that has often become ancillary by the time a court considers a motion for summary judgment. Because during discovery, a defendant will often, virtually always, offer some reason for their action, be it through a deposition, through a declaration, some other paper evidence. And so for the court to focus on whether a plaintiff has triggered a burden of production that a defendant has already met strikes us as beside the point. And of course, that's what the court said in Ames and Hicks. That's what the D.C. Circuit has said. And we think to the extent that there is confusion about McDonnell Douglas, Justice Gorsuch, it would be helpful for this court to clarify in remanding to the Sixth Circuit that because Ohio has already met its burden of production here, the court can and should proceed to the ultimate question of whether a fact finder could find discrimination.
Yeah, I'm sorry. Go ahead.
Go ahead.
Well, I do want to pick up on that point, Ms. Robertson, that at least in many circuits, the step three inquiry on pretext has become kind of an absolute condition that has to be met. You have to show that the reason offered by the employer is pretextual to get to trial. And Again, we've never held that. This court's never done it in the summary judgment context. I understand other circuits may do it differently, but many have done what I've described, which seems a little inconsistent with, as Justice Sotomayor pointed out, the motivating factor test and with the but-for causation test, where there are two possible causes. One might be non-discriminatory and another might be discriminatory. Any thoughts about that for us?
I'm mindful that the court has before it a pending petition, and so I won't comment on whether what the Ninth Circuit did specifically in that case was incorrect. I will say that we understand that any plaintiff that can produce evidence from which a jury could infer discrimination should go to trial.
Okay, thank you.